In the video you're about to watch, John Deaton explains everything you need to know about the repo and the SEC's lawsuit. John Deaton is he's an attorney for the crypto law firm in the US, and he has been updating the XRP community about the potentials of the case against the repo and the CTOs of repo. So John Deaton is the attorney who is representing all the XRP community holders, about 65,000 people who signed a petition. John Deaton is representing them in the lawsuit. So if you watch this video till the end, you are going to see the reasons why the SEC lawsuit is just not worth it. Please watch.
And then we got more evidence. This is overwhelming evidence. It's overwhelming. We get to, now that was 2018. We get to 2019. Coinbase, the most conservative of exchanges, with their sophisticated securities lawyers, goes to the SEC and they say, we have run XRP through our framework. The framework that Valerie, the czar at the SEC, complimented Coinbase about publicly. We've run it through our system and XRP is not a security. We're gonna list it unless you tell us otherwise. They leave that meeting and they list XRP in February 2019. If it was so clear that XRP was security, Coinbase wouldn't have listed it, okay? Coinbase wouldn't have listed it. Then we go further. That was January of 2019. Now we get to June of 2019. And what does Ripple do? Ripple actually files a document with the SEC that they're going to purchase 9% of MoneyGram. In the document, in the filing, it talks about XRP. It talks about how XRP is going to be utilized with MoneyGram in cross-border remittances. If it was so clear that XRP was a security, why would you allow that to go forward? They know, the SEC knows that Ripple is going to pay or transfer XRP to MoneyGram. Did the SEC believe that MoneyGram was a hodler of XRP, or are they a money business? And they were then going to sell that XRP on exchanges to you, DAI, and to me. Right. And if it was so clear that XRP was a security, would the SEC allow retail investors to get this unregistered security? Of course not. And then we get even further. Now we're in 2020, the year of the lawsuit. And we got to look at what did market participants think, right? Well, we've got that Baylor Inc. filing in January 1st of 2020, where they say to the SEC, look, we know that there's uncertainty with the digital asset space, but we want you, SEC, to rest assured that Baylor will not sell or trade potentially unregistered securities. We're going to only trade the 3 cryptocurrencies that is generally accepted by the financial world, including the SEC, to be non-securities: Bitcoin, Ethereum, and XRP. That was in January. That was 11 months before the lawsuit. And then finally, DAI, we got another piece of evidence. We have the email from an XRP holder literally within 60 days of the SEC filing the lawsuit that says, hey, is XRP a security? And what does the SEC say, DAI? We have not made a determination that XRP is a security. That was less than 2 months before the filing of the lawsuit. So when you take all that evidence and you take it together, there is no way, it is impossible for the SEC to meet its burden to prove that Brad Garlinghouse or Chris Larson had actual knowledge and belief that XRP was a security, or that they were so reckless because it was so obvious to the world that XRP was a security. If it's not obvious to your own SEC enforcement lawyers who are experts in what is or isn't a security, how could it be obvious to these 2 executives?
Well, you know what after hearing you go through all that, the conclusion that I come to, because we've accused the SEC of a lot of things, but I've never accused any of them of being stupid. And the only conclusion I'm no attorney, but the only conclusion anybody with an ounce of common sense can come to here is that this lawsuit, all of these lawsuits, were filed knowing that they couldn't win. And if that's the case, you got to ask what their motivations are.
Well, I mean, listen, you saw that recent interview, or at least clips of it, of that Joseph Hall guy, right? That from the SEC that Tony at Thinking Crypto did. Well, even though he was a moron and dismissive of saying, oh, it's a conspiracy theory, even the SEC's own loyal people said he was perplexed why the SEC brought this lawsuit. Everybody think about that. Why? Why did they bring the lawsuit? You can't prove this. You allowed this asset to be traded for almost 8 years. Okay, you allowed all the things that we went through in this interview with UDI, all of those things. Why would you file the lawsuit? Why would you go after the executives in a non-fraud case? If you go back and look at all securities enforcement actions, when you sue the executives is when you believe they've committed fraud. Yes. Why would you file it against them when you know you can't? If you know you can't win, then maybe you're not trying to win. Maybe the filing of the lawsuit itself was the goal. Maybe that was the end. Maybe that was everything, right? File the case against them. Think about this. Joseph Grunfest, who is very, very loyal to the SEC, he believes in it as an institution. He said, in the history of the SEC, there had never been an exodus of so many leaders in the SEC leaving after filing such a significant lawsuit. He called it a mass exodus. Think about it. Clayton left, Hinman left, Mark Berger, the director of enforcement who helped write this complaint, left, the director of trading and markets left. All of these people left. As they're walking out the door, they slapped the most significant SEC enforcement action in modern history because they didn't have to prove it. So if they don't have to prove it, are they willing to file a ridiculous lawsuit that can't be proven? Sure. Wow. If the lawsuit is the weapon.
Well, John, I mean, the thing for me when I hear this is that tells me that this is just a matter of time at this point. If it's a matter of time, that makes me very bullish on Ripple, on my Ripple equity and my XRP.
Listen, I've said this before, and and it should be known. Even Charlie Gasparino and Ellie basically said in their opus, they said, John Deaton's no fanboy of Ripple. I've always been focused on the XRP holders. And I've never been a defender. I don't have anything against Ripple, of course. But let's talk about that for a second. Just 1 second for people who want to be worried or concerned about the lawsuit and its impact. Can you imagine what I said earlier? Can you imagine being investigated for 2.5 years, going through every sale that was ever made, going through every advertisement that was ever issued, and after 2.5 years of an exhaustive investigation, they don't find one single instance of fraud, misrepresentation, or omission? That's got to give people some confidence. I wouldn't go on a limb and predict that this case against the two executives gets dismissed if I wasn't 100% sure. So, I can't say, go out and buy Ripple. That's not my job. But I can tell you, there's a lot of cryptocurrency platforms that would not survive a 30-month investigation.
it's likely they are using these things to hold down XRP and all investors. So okay, thank you so much for watching till this end. I hope you enjoy this news and information. Please don't forget to like this video and don't forget to subscribe. Thank you so much.